Hi there, everyone, for the JD4K family. Welcome. Thank you for dropping in, stopping by, taking a look. Okay, so we are recording. Thank you. um, so this is JudgeDesire For Knowledge. That's me, my channel, and this month is the ending of the month, which I use my legal matters instead of my talk show, My Truth Real Talk. So I am recording this. This one's taped because legal matters takes time, and I'm going to try to be brief and as simple as I can so that the process is not as hard as you think it is, or laypersons, people that don't know laws and aren't attorneys. They would believe that it would be too hard and difficult and tedious, but sometimes things aren't as hard as it looks. So anyway, so this is the month that we're doing Evictions Part 2, Tenants Rights. I did a Part 1 on landlord and versus tenants or something like that. It's back in on my page. You can go check it out. And that was done a month ago. So tenants should be allowed to actually live freely and in an environment that is healthy mentally and physically. Um, Also, tenants should have legal rights to live the peaceful life they're supposed to. When they're rentals, the landlords are obligated to have everything that you need there, utilities and maintenance, unless specified in the rental agreement. These things should be already maintained and habitable so that one can live there and not have to worry about things unless things break down on you. So, an agreement called a lease by law is a stipulation, which is an agreement between you and the landlord. If you don't like the agreement the landlord writes up, then you can come to an agreement together, maybe, if that's a landlord that will allow that, because not many of them are that nice. So, and I'm not putting them all down because my parents were landlords. So, but you got the good landlords and the slumlords. So basically, what I'm seeing is that the agreement of the lease is by law what was provided in it, that the landlord have to have a suitable place, okay, for you, meaning water, hot or cold, heating, and all the other essentials, a refrigerator. If you have an air conditioner, you're lucky, but if you bring one in, I believe you need to ask the landlord or not. Some people will allow it, but it's not a part of what the landlord has to give you. In other words, I'm just stating the ones that they are essential to giving you as a renter. Of course, bathroom and all the facilities needed and required for our daily human for our daily care, I should say, food, storage of food, places for that, and so on and so on. So, if you find that you have issues with the landlord for things like after you move in, because sometimes that's when it happens. If you see issues before you move in, you need to have the landlord to straighten it out at first before you even move in. Sometimes it's hard because you need to get in there, but once you get in there, the landlord may not fix it, and that's where the problems brew every time. I've seen this in court and outside of court, and basically, and when I was renting years ago, that landlords will have you move in and say they'll fix it. No, you get an understanding, have it in writing if you need to, and let that landlord know. No, I would prefer before I give you the rest of the monies, because you got to give up security for at least 1 month. If they ask for two, you hold the second one until they fix what they need to. Because believe me, once you get in, if they haven't fixed it and you have paid them, most likely the slumlords, the ones that are out there, they usually don't get back to it. And then this all ends up into you not even staying there. Eventually you lose out your monies, your security. You're gonna want to go to court to get that back. But I'm jumping ahead of myself now, so I'll slow down. I just want to make sure that this is done before the move. Now, if after the move you see that things are not working and properly or anything that was inside the lease that's supposed to be functional, you signed it, then you have issues with the landlord, even after negotiating with him, then I suggest that you put it in writing, you know, about the to the landlord in order to have a future record of it. Because if this goes to court or you file a complaint against your landlord outside of court, then these things are recorded that you filed you gave him a letter and you kept a copy, whether you certify it or not certify it. I'm not saying certified, but if you want it to be certified mail, sometimes they won't even pick it up. But the point is that you prove that you have given this person and he or she has received it, the landlord, a notice from you stating all the issues and what date it will be fixed by. And then the landlord is supposed to come and take care of everything. But the notation, the information is basically because in order to bring things to court, to prove information is to provide information. You don't just come and verbally say, "Oh yes, judge, I spoke to him many times." That a lot of tenants do that, and we know it's true. But some landlords will say, "No, I didn't talk to him. I don't know of this issue." So therefore, your backing would be to provide yourself with ample proof in case you have that type of landlord, which are sometimes slumlords because they don't want to take care of stuff. They just want to receive the rent. Um, then you're going to want to do that, have it recorded for your records any way you want. You don't have to do it the way I say it, but make sure you have proof that the letter was given, stamped of the date, time, if even, and where the location was that you gave it to him, all right, or her. And if because this is where you can have to notify the landlord, because if you don't notify the landlord, the courts will look at it and say, well, we don't have any proof that you did or didn't. So that's why I was saying that you need to do the writing in writing, you know. I don't believe in taping anyone because it won't be submissible in court. You won't be able to submit it because either that person didn't know, unless it's agreed by you and the party, the landlord, that you can tape him, that you have actually required and asked and suggested him to, um, you have notified him to actually take care of the situation. If, with their permission, it can be submitted. But if you're just going to tape someone and bring it to court, it'll be thrown out. So this is why we do written contracts are done. Even if they don't sign, everything is done with writing instruments. So that's the best way to get things done in court, and not, it won't be thrown out because it's not something that was done without the knowledge of the other party. If you've given a written notice and the person accepts that notice, then they already have it. All right, so the first thing I want you to be aware of is that when you get to this conclusion that things aren't going to happen for you in the court of, well, outside of the court of law, you can bring in the court of law by filing a petition in the housing court of that county where you live against the landlord. Okay, that's one suggestion. Make sure you get the venue right. You know which county you are in. So if you're in New York, it's New York Housing Court. If you're in the Bronx, it's Bronx Housing Court. But it has to be a housing court, and those are called civil courts, lower civil court. So if it doesn't say housing, then lower civil court deals with housing, landlord, tenant issues, and all kinds of small claims and stuff like that. In the petition, you should be writing the reasons why the court should listen and hear your case against the landlord. For instance, write all the things that's been happening that hasn't been taken care of, or etc., and make sure to include the need of maintenance required by the landlord. That was suggested in the lease. If you have the lease, bring the lease with you. That can also help prove your case that this wasn't done. Take pictures of the problems, have it the lease with you at that time as well when you're filing, or the date that you go to court. You can either file it with the court when you go file the petition, or you can bring it in as your proof that on the day of your trial. All right, of the trial. So the court will instruct you. They'll instruct you how to service upon the attorney, service upon the landlord, um, by mail or in person. Some of them, they do it themselves. I'm not sure. Everywhere is different depending on the seriousness of the, let's say you and your landlord do not get along and it's seriously order protections and stuff like that, then they'll send someone else to do it. But it's according to what the judge orders, whether it be mail service or personal service. It will be up to the judge. All right. If you have concerns, then you need to speak to the judge and ask that judge to do it a different way. If that can be possible, it will be done. If you need the court to do it for you, they have suggestions like that where they mail out the form to your landlord themselves. All right. Also, you can another way of, also, like I said, the venue and the court will instruct you on how to do the services. After that, you're going to want to know, do you want to proceed with an attorney or do it pro se, which is self representation, representing yourself. Usually these are minor stuff, so you can actually do it yourself. I brought my landlord years ago to court, and I actually won the case. His attorney was big time, and he couldn't even stop me. So you got to know what to do and how to say it, and this doesn't take a professional. Attorneys are professionals, but for housing, I wouldn't spend the money just to do that unless it got out of hand and you need to retain an attorney later. Then you would ask the court for a recess while you retain an attorney. All right, and so if you, because you know the attorney is going to have the landlord will have an attorney of their own. They normally do. So, and if not, they'll be themselves. But normally I've seen landlords have landlord attorneys, which are usually the best. So you got to make sure your stuff is together. And if you can't do that, then find another suggestion would be to find a advocacy group that can assist you in tenants' rights. They have a few. There's one called CASA out there who specializes in tenants' rights, and it's Community Action for Safe Apartments. So that's CASA, and you can Google these things and find people that advocate for you in your favor or can show you steps what to do to make sure your landlord does his job. Right. All right. So basically, what else do we have here is that after filing it through the courts, you can also file a complaint. If you don't want to file a petition and go to court, you can file a complaint to the Department of Preservation and Development, Housing Preservation and Development, HPD. All right, and they have a central complaint bureau to help you and assist you if you don't want to go through the courts. If there are heating issues and non-working appliances such as stove, refrigerator, no water, etc., you can also call 311 or go online to newyorkcity.gov. They should have a lot of information there that you can retain. Or when you get into their website, newyorkcity.gov, do a search on tenants and tenants' rights, as well, and that should help you. Okay, so another thing that I wanted to state was that lease violations are very serious. So if a landlord breaks the decision of lease agreement, the lease agreement that you both had together, you can file a petition against them in court based on what the break in the lease is. Like I stated, you're not supposed to break the lease, but neither is the landlord by not giving you water, heat. You're breaking the lease. That's like evicting someone because they're not going to be able to actually live in the home, so it's not habitable. So therefore, that's like evicting someone without actually pushing them out, you know? because who can live without heat in the winter and water to drink and bathe and all those things? So those those are considered lease violations by the landlord. Um, yeah, because they always look and see how you broke your lease. So you need to see how they're breaking the lease they actually wrote up themselves, and you can use it in the court of law against them. So other remedies are, if things aren't working out, you can fix it yourself, save the receipts, and deduct them from your rent. That's one suggestion. Another one is to report to code violations for the housing inspections, and they'll come out and they'll look at it and tell the landlord he has a couple of days, and if he doesn't, they'll be back out and they'll fine him or her. So check that out. Report code violations to housing inspectors. Okay, those are really important things to do. I wouldn't know the original number for that. You could Google it. It's called housing inspectors, and you'll see that it's code violations. Okay. Also withhold rent, but put the rent in an escrow account, because by you withholding the rent, the landlord can actually uh, take you to court and file an eviction order on you, or eviction suit for non-payment of rent. So that's their trick. So you got to keep an escrow account. You might not want to pay rent, but don't go out there and spend it, because if he's not doing his job, then you want to withhold and go to court. You can't just withhold and not pay. You put it in an escrow account or your bank account until the day of court or the complaint or is filed, and then the courts will see your receipts that you do have the back rents actually in your account, but you weren't paying this landlord because he wasn't doing his job. All right. And the fourth one is you can either break the lease and move out, which is easy, but not so easy because now you have to go out and find another way, apartment and this and that. And sometimes breaking the lease can cost you in court as well. Depending on what your lease agreement was with the landlord, then that will have to be between what the lease states in it. And that's why it's very important that you read your leases so that you can get your securities back full 2 months. If you did get 2 months and they want to give you 1 month and you agree on that 1 month, then that's what you get back. Don't forget to read everything. And my last suggestion is just to sue the landlord altogether, because after paying the landlord, you can either continue paying rent and then sue the landlord for the difference. That sounds good. Between the rent you pay and the value of the defective premises. So you can do that or just sue the landlord, period. So there's a way to continue paying, sue the landlord, and take the difference out of that with the defective premises in court, or just sue the landlord, period. And that also means that if you're leaving and you're going to sue the landlord after you've left, you have paid up your rent and you're out. That's the way of suing the landlord that way. After, and you take him to court and you want all your monies back. Or the way I just stated a minute ago, continue paying the rent and then sue the landlord for the difference between the rent you pay and the value of the defective premises. So you're going to have to find out, get an amount on how much damages that cost you per day to not have water, refrigerator, or whatever it is. Or let's say the refrigerator gave out and he didn't come and your food is all no good now. So those come into account as well. So I hope you like this legal matters. Part of my show, monthly show, is legal matters and tenants' rights. This was good. I hope you all did get something from this show. Oh, I'm really my my throat is dry. I really hope that you all got something out of this and learned something. If there's any comments, questions that you have for me, I gladly be able to answer them. You can email me, put it in the comments description below. Please subscribe, like, and share, of course. and and you can comment also if other things you need to know, or you have a comment you want to state. I'll get back to you. I'm sure everyone has questions about stuff. But again, I have the monthly legal matters every month, fourth week of the month, and then I have my talk show, Real Talk, My Truth, Real Talk, every Saturday at 3 p.m. So join me, Judge Desire for Knowledge, here on both channels, monthly and weekly. All right. I hope to see you all soon. My JD4K family, all be well. I hope all is well and that you're not going through this process. But if you are, that's what I'm here to do, help everyone get through it. The channel is for that. Legal Matters is to help people. And my talk, real my Truth Real Talk, is also a talking channel, talk show, where I come talk with you about things that's actually happening, topics, and we relate with each other. So if you want to come check that out every Saturday on YouTube at 3 o'clock, you can. It's really cool, and you can bring in your suggestions. You could talk live with me with every topic you want to put up, but I usually have a topic ready. If you want to share topics that you want to talk about, write me, email me, or leave it in the comment box. Okay? All right. So I hope you all have a great day. Stay blessed, loved, and appreciated. Ciao.